Business partner Reddy Neumann. Today we're going to discuss about the priority date predictions from June 2022 to September 2023. This is the most hot topic for a lot of immigrants who have been waiting for a long period of time in the United States for getting their turn in filing the adjustment of status. And we're going to also discuss about this HR Work Authorization Act, that is where whoever is on H4 will be given EAD irrespective of whether their spouse's I-140 is approved or not. We're going to discuss about that. We're going to discuss about the I-140 trends, what's going on the premium processing applications, especially for the downgrade applications that were being applied before. We're going to discuss about that, and plus what is the time process it's taking for the PERM process, including the prevailing wage, and once the prevailing wage is approved, if you file the PERM, how much time it's taking. Emily, priority date predictions though, that's a lot of people, about 20% of the questions come under the priority dates. We've been wrong in predicting the priority dates very many times. I think so that you are the second worst person in the entire world in predicting the priority date, and I take the credit to be the first person though. Now, what we noticed, Emily, recently, according to your immigrationgirl.com, where you publish from my desk what the approval comes in, not from the entire office. So what is the trends there? I mean, we see a lot more approvals coming in the month of April and May. But what are the trends that you see there?
Yeah, so the approvals are coming faster, which is great, but the annoying aspect of it is there's no rhyme or reason to what's getting approved when. I've recently updated the all of the case information today, and one of the cases that was filed in February 2022 has already been approved. And then right next to it, you have a case that was filed in October 2021 that was approved. And what about the October 2020 filings? It's just so random. There's no rhyme or reason to even the priority dates don't make any sense. To what they're picking to approve. The only good news is they seem to be picking up the pace. Hopefully we'll get the data with the inventory that shows us, not the inventory anymore because they stopped doing that, but at least telling us the quarterly report of second quarter of the fiscal year, how many 485s do they approve versus first quarter. Hopefully we'll see that difference, a big jump, which gives us good indication that we won't waste as many green cards as possible, partly thanks to all the letters you guys have been writing. But I think the pace of the 485s is ultimately what's going to determine what the dates are going to do between now and September 2023. What are your thoughts on that?
Yeah, it's based on how the adjudications are happening, Emily. I think I'm pretty positive things are going to move forward.
At least in October.
At least in October of 2022, that's when I can think that the things are going to move. According to the predictions of us and some other people though, they're predicting that there may be anywhere between 50,000 to 110,000 extra green cards available. Again. Because the consulates are not fully open though. The Chinese consulate is not open, the US consulate in Mexico are not fully open, the US consulates in India are not fully functional, especially for the family-based preference categories. They are the least ones. They have given preference to immediate relatives, they have given preference to other categories, but when it comes to the family preference categories, they have not given the importance. Because of that though, there is an expectancy anywhere between 60,000 to 100,000 extra green cards available. Now, irrespective of how they are adjudicating, not first come, first serve. There are cases you published today that got approved in 80 days, 485 application filed in February, gets approved in May first week though. So irrespective of how they are approving, but their approval ratings have gone up very significantly. So based on that, I may be expecting the priority dates to move, but I can be wrong. And the pressure that our guys are building on by writing the letters to the congressman, by writing the letters to the USCIS, by writing the letters to the ombudsman's office, they're building a pressure on them. That is acting. If you look into it, when we noticed that in June or July, the State Department has changed its version. Previously, they said we are expecting to use all 485 applications. Then they started predicting, no, we are not expected to use all. Then they said we may be wasting 100,000 green cards. Then definitely we all panicked at that point of time. Our clients panicked, and they wrote letters. I think so because of that effect. The things responded very much in the last quarter. They adjudicated a lot more application, but then again they slipped in the first quarter of 2022, which ended in December, in the fiscal quarter of 2022, which ended in December 31st of 2021. I did see that some more improvement in the second quarter, but in the third quarter, that is April and May, I'm looking at a lot of improvement in there. Hopefully so in this quarter that ends in July. I'm expecting, no, it ends in June though, June 30th. I'm expecting maybe 80,000, maybe 90,000 green cards, and that may lead to some improvement, but that's my opinion. But can you put a date what it's going to be in October of 2022? What can you put a date? Well, we cannot put a date at this point of time. It all depends on you guys, how much effort you are going to put on to improve the dates. Right now, for the date of filing, as you already know, everybody, it is December 1st of 2014, which is very good. Last time in October of 2020, though, as you already know, that it was December 1st of 2014. So, sorry, January 1st of 2015. And right now it's December 1st of 2014. There is only 1 month gap. We do expect, I do hope, now I'm not telling you what it is, I do hope that it will move to 2016. I do hope now. Hope is different than what actually happens, guys. So don't come back and say, hey, you predicted to be in 2016. I do hope it moves to 2016. So definitely, if you keep the pressure on the Congress, if you keep the pressure on the administration, we can get this thing done. So I'm assuming that all the people who are listening to this, we have audiences including our Tuesday, and also we do have a Sunday TV Asia Live. So all of those combined, we have about 20,000 people. If all these 20,000 people will write letters though, definitely that will be a big impact. There are extra people that watch in other shows, so anywhere between 30 to 40,000 people watch our shows. So if all of them write letters though, then we definitely can expect the dates to move.
Yeah, and USCIS is having an engagement section next week in order to discuss how they're addressing the backlog. So hopefully we'll have some more news on what additional plans they have. They have made some changes. They've extended the EAD, auto extension, which means they don't have to worry about hurrying up and approving these EAD renewals from 2 years ago. They can instead focus on hopefully approving the green cards if they're doing what they should be doing. They don't have to worry about L2 EADs anymore. So they're freeing up resources. On top of that, they've transferred all these cases to NBC. So now TSC and NSC should be able to get those I-140 downgrades from 2020 finished finally. So they're doing things. Hopefully we'll get more information next week as to what all they have planned for the rest of the year.
H4 EADs are already authorized to work. What is this law, HR 7472, bring in new though?
Yeah, so remember the H4 EAD that we have now. Number one, it's not a law, it's a regulation. Regulations are governed by the administration. So when a new administration comes in, they might choose to eliminate that regulation, which was threatened by Trump the entire administration. We also have litigation where a lawsuit can threaten to remove a regulation if it wasn't passed appropriately. That happened to the STEM OPT back several years ago, the 17-month STEM extension. So regulations, yes, they are the law, but they're not as strong of a law as something that's passed by Congress.
So in simple English language, if I have to tell the audiences, if Trump comes back in, he can take the H4 EAD off.
Right. That's how it is now. But if Congress steps up and actually passes a law that says H4s are authorized to work incident to status, which is how L2s have always been, then when administrations come and go, the only thing that can change it is another act of Congress, which you all know is very difficult to actually accomplish. So that's one thing. It will protect the H-4 EAD from additional, administrations coming in the future that might be anti-immigrant. Number two is it makes it available for all H-4s, not just those that have the approved I-140 or have gotten the 7th year extension for the spouse's H-1B. So definitely some positive items there. The difficulty is, anytime anything immigration, pro-immigration is brought up in Congress or the Senate, the immediate Republican response is, there's too much going on at the border. There's too much going on here. We need to protect U.S. workers. We can't focus on this right now. You're seeing it right now. There was another push yet again for some sort of immigration reform that they knew they couldn't get through the reconciliation process. So they were going to sit down and try to come up with yet another comprehensive option. And that's already fallen apart before they even got started. Because number one, we're coming up on an election year, and number two, they're always pitting groups against each other, and it's always got to be border security. Anytime you want to do something for legal immigration, you've got to fix other immigration, which makes no sense.
So definitely this will have a lot more employment authorization, and EAD application fees won't be there too, just like the L2 people.
Yeah.
They don't have to file the application process, and this 540 days is not applicable for them because they get automatic extension anyway. Coming to the premium processing, Emily, of the I-140 applications though, we always recommended people who are been downgrading applications never to file the premium processing, but we told at the same time, convert it later on. And after we converted later on, premium processing, some of them they accepted, some of them they didn't accept it. What's going on that? What's the trend right now?
Yeah, so many times we've had to submit that premium upgrade time and time again. Some of them it takes 3 tries, some of them it's 5 tries. Now all of a sudden we're noticing a trend that every single one that we're submitting to upgrade from these October 2020 downgrades, they're immediately accepting it and they're processing them within the 15 days. So that's definitely an improvement. So if you do still have an I-140 downgrade pending, and you've tried upgrading it before, now would be the time to try that again, because it seems like they probably now have the capability to access those old labor files to get the original to be able to actually process it in premium.
That's good news. Another thing, PERM application process. Now, the entire application process may take anywhere between, for the prevailing wage that you need it, it is taking approximately 5 to 6 months to get the prevailing wage. Now, once the prevailing wage is approved though, you can file the PERM application though. The PERM application is taking approximately 6 months right now to get it adjudicated. What these timings used to take about 1 month before to 2 months, and now they are taking 5 to 6 months. There are 2 different processes. You need both of them for your labor certification to be approved. Not only they just do, you have a recruitment process, there's an additional 4 to 5 months. So if you start the case from the scratch though, the minimum time it will take right now is definitely more than 1 year. The maximum time that it may take is approximately 2 years. So especially if you are on H-1B and you're coming very near to the 6th year, you need to be very, very, very careful. For a lot of people who are on H-1B, you guys already know, we don't have to explain that. H-1B is only valid for 6 years. After that, what are you going to do? So plan your life a little bit earlier though. Try to get the labor certification I-140 earlier. You already know that once the I-140 is approved, you can extend your H-1B indefinitely though. So definitely you should start applying for the green card as early as possible. As soon as your H-1B is selected in the lottery, you should try to file the labor certification. Now, your green card, a lot of people have a lot of predictions. Maybe it will take 150 years, maybe it take 10 years, maybe it take 5 years, maybe miracle will come in, maybe COVID will fall again. Who knows? The prior date might move. So definitely for that purpose also, you should file. But for all that, you cannot extend the H-1B unless you file for the PERM application. So you should take care of it as early as possible. That is the best thing that you can do. Any other suggestions, Emily?
Yeah, I think people still are thinking in the old way where you could actually start the labor certification process in your 6th year of H-1B, make it all the way through the labor and I-140 and get that approved in time to file your 7th year extension right at the very end. That is impossible. There's no possible way that that can be done anymore, assuming that there's not a valid prevailing wage. If you're starting from step 0 of submitting the prevailing wage, plan on 2 years. So make sure before you enter your 5th year, so by the end of your 4th year, you should have a prevailing wage going. Otherwise, you may max out on that.
Let's go to the question and answers. Megha Kandanwal, she did travel to Canada, and unfortunately, she didn't got the I-94 extended. If your I-94 is not extended, though, your chances of getting the H-4 already in there getting denied is almost nil. The article you're pointing out is more pointing out to the people who already got their I-94 extended. But Megha, you can contact me in our daily conference call, which I think so I already addressed some of the issues that you presented. You can come to the daily conference call. I will address those issues though.
Anoop wants to know if there's any news on interfiling. He's got a downgrade from October 2020 and did the interfile in December. Still no idea what's happening. Yeah, we're seeing the same exact thing. Not one result from interfiling at all. We had one, I can say, that was approved shortly after an interfile, but it was so fast that it's very likely that it wasn't accomplished by the interfile. So unfortunately, no, we're just not seeing that happening. And we don't know what they're doing. We've got all these October 2020 cases that are just not getting adjudicated, that are eligible. They're telling us, hey, do this, upgrade to EB2 because we have more green cards available, yet they just sit on it. I even have RFEs coming in for cases that we did do the interfile, asking us, as if we never submitted it, to submit a supplement J, like an old school 485 RFE. And these are interfiles that were done in February, early February. So they've clearly not got that process figured out yet, unfortunately, but hopefully they will in the near future. And that's something that I plan on bringing up next week in their stakeholder engagement.
Abhiram has this question. His I-140 has been withdrawn. They're refiling it. He has masters. The requirement is that master plus 1 year experience. He may not have some of the pay stubs that he worked for the previous company. Will that be a problem? Do they ask the pay stubs? 99.9% of the time, they do not ask the pay stubs at all. Surabhi Verma, a letter was sent to, she got the green card. Congrats. You've been a good audience for us. I remember your name a lot. Is it necessary, mandatory to get SSN card and driving license updated? Surabhi, I didn't get my SSN card updated as of now yet. It still says that valid only, with employment authorization. So so it's okay if you don't get updated. That's not a big deal. You don't have to, driving license also, if you don't get updated, not a big deal. Yeah, whenever you have free time and you want to visit the Social Security office, you can. You're in no hurry to do that. Go ahead.
Krishna has written a letter, thank you very much, and he says his ex-employer asked him to pay for the PERM and H-1B when he was leaving the company and he had to pay it. Is this legal and what can I do? For the PERM, no, it is not legal for the employer to ask the employee to pay any portion of the PERM process. Filing fees or legal fees, there's no filing fee, but the advertisement cost or the legal fees can't be paid by the worker, and they're not allowed to recoup that money from you if you leave. So that's something that you could make a complaint to the Labor Department for to get that money back. As far as H-1B fees, there are certain fees that the employee is not allowed to pay. Again, you can fill out a WH-4 form with the Department of Labor, Wage and Hour Division, and they will investigate that and try to get your money back and may open up an audit of other files to see if the employer has done that elsewhere as well.
Ragini Gupta has this question, wrote letters to the Tennessee Congressman. Under this, what scenarios can EB3 move, either in fiscal year 2020 and 2023 though? At this point of time though, to move EB3 beyond January of 2015 though, it may take a long time. I don't know if it's going to be moving in 2023 also. Ragini, if you have an option of filing an EB2, definitely you should try to choose that option too. Option also. But you need to understand the unused green cards in the EB1 will fall to EB2. We do expect some unused EB1 green cards because we have almost 80,000+ green cards available in EB1. Never in the time there was a demand for that many green cards. So even if about 30,000-40,000 extra green cards or even more than that of EB1 falls into EB2, EB2 will have approximately 80,000+ they have, plus about 40,000-50,000 that will fall out from the EB1. So they may have anywhere between 120,000 to 130,000 green cards in EB2 though. When it comes to the EB3, they do have 40,000 plus about 40,000 extra green cards for this year. That's about 80,000 green cards that are there. There will not be any fallout from EB2. As you know, that EB2, a lot of people have been upgrading, they're refiling their applications, they're getting them approved right now. So there may not be many cases that will fall down into EB3. And the unfortunate thing was that the USCIS and State Department, they have no clue how people work. They did not estimate that so many people will file the downgrade. They have no understanding of our community at all. As I pointed out, that State Department is from Mars, the USCIS is from Venus, or maybe I said the other way around. They don't live in this world that we live in, okay? Because when they moved the priority date though, they should have moved EB2 also forward. They moved only until May of 2011 for EB2, but January of 2015 they moved EB3. They only looked into the stats of the I-140 approvals and said, okay, the stat says that less number of EB3 approvals are there in I-140, let's move EB3. They had no clue, or I don't know if they understand, especially the State Department understands, that we can file a downgrade application. And you'll be very surprised, Ragini Gupta, that in September of 2020 though, a lot of people didn't know that they can downgrade it. We had a video that was made in September of 2019 that you can downgrade and apply the application because there are some dates that moved forward from more than EB2, EB3 have moved. We've been downgrading the applications for Chinese nationals for a long period of time. I mean, from 20 years we've been doing downgrading of the applications for the Chinese national. We didn't have any problem. So I don't know if the USCIS was aware of it, but at this point of time, we're very clear that they are clueless about how many people would file under EB3. So we all filed under EB3 because that was current. Then they said, whoops, we didn't know that these number of applications. Then they opened up all the files. They found out they're not EB2, they're EB3. Then they figured, no, we have more number of cases available in EB2. Guess what? All of the guys are going to EB2. So definitely there's a lot of confusion there. I'm not telling that there's no chance, because there's always a chance for EB3 also, because most of the people are now moving to EB2. There's a chance, but the likelihood seems to be that EB2 may move a little bit more advanced, especially until the end of 2023, that is September of 2023. That is our estimate at this point of time. But we can go wrong, hopefully so. If they adjudicate all these applications in time, then definitely we have a chance.
Surya wants to know, how many days before my visa stamp expires can I enter the US? His visa stamp expires August 2022, but he's already got the extension approved till August 2025 and wants to know if he can enter in July 2022. Yes, you can, and show your extension approval notice. So the visa stamp that's in your passport only has to be valid on the day you're entering. So technically, even up into August, you can enter on that visa stamp and be allowed to stay for whatever time is left on your H-1B. Now, in your case, you already have the extension approved, so you can show that new approval to the officer and make sure they give you the I-94 till August 2025, not August 2022. Check that before you walk away so you can get it fixed if they have it wrong. But yes, you can travel in July in that situation.
Bharat Rawlapudi has this question. Wrote letters to the congressman. Thank you so much. I'm very proud of all the people who are writing the letters, though. How do you know if the case has been transferred to the field office after it's been transferred to NBC? Ugh. The only way that I can think about is that to file a freedom of information that may actually have a knowledge about it. But otherwise, by looking online status, though, we cannot. The second way to know is that if they issue an RFE, then you can see, was it issued by NBC, was it issued by the field office? Then you can find out if your case has been transferred to the field office. Though, one thing people need to understand: what is field office? What is NBC? NBC is more like Texas Service Center and also Nebraska Service Center. It's called as National Benefit Center. What NBC is that it is in charge of all the field offices. That means that they distribute all the caseload for the field offices, though. And some of the cases are going to field offices where people don't belong to. For example, if you are from California, they're sending it to Florida, because if Florida, USCIS doesn't have much work and their offices are more efficient, they're taking all the cases. Even though you are in California, we've received a lot of RFPs that are coming in from a field office that are different. Our clients are asking, oh, I'm not in Florida, why am I getting this one here? Well, that's fine. They have an authority to do so. And getting an RFE, of course, is the best thing that can happen right now. We see a lot of RFEs coming on medical. Some of the RFEs are coming on 485J. I tell my clients, that's a good thing, buddy, if you're getting an RFE. And we respond to the RFE, the approval ratings are way, way higher, very, very faster for the RFE responses, though. But yeah, those are the only two ways that I can tell the field offices have been transferred or not.
Morelli wants to know, when can we expect premium processing for the EB1C I-140s? So we don't have any official news from USCIS on that, no rumors really from them. But what I'm hearing is June 1st is likely when they plan to implement that first wave of new premium processing options.
Aru has this question. Does the automatic EAD extension rule apply to advance parole as well? He wrote letters. Thank you. Unfortunately, no.
Yeah, and that's the difficulty, is because they decoupled that EAD and AP and that said, oh, no, you're fine because we're automatically extending your EAD. Well, now, great, but I can work, but I can't travel because you haven't approved my AP, and those processing times are ridiculous. Ashok says he has his I-140 amended, and the lawyer is saying we can interfile to EB3 without any problem. Does it make sense? So I'm guessing you mean interfile to EB2. And there's a problem there, because an I-140 amendment, USCIS recently came out and said that basically means the previous I-140 approval you had disappears when you amend that I-140. So if you mean that you downgraded from EB2 to EB3 by filing an amendment, your EB2 doesn't exist. Now you can get back to EB2, but you have to file another I-140 in EB2 based on that same labor certification. Don't file it as an amendment this time, just file it as a regular I-140 unless it's a successor in interest situation. But you do have to get the EB2 I-140 filed in order to interfile back to EB2.
Question, Emily. The question came to me, but also I'll put to you. This question comes from B from YouTube. If you are the USCIS director, what are the things that you will do?
Oh my gosh. Eliminate interviews.
Eliminate interviews unless
there is... Shorten all the forms.
Shorten all the forms.
Let's see. I would give EAD and AP on the 485 receipt notice.
Okay.
I would move...
That eliminate all the processing of the EAD in advance parole, yes.
I would...
That will reduce the time by about 30 to 40% officers working, okay?
I would figure out another way to do this whole interfile mess that doesn't involve the supplement J. I'd probably get rid of the supplement J. I would move visa processing for renewals back into the US like it was 20 years ago.
What you mean to say is that for the people who are going for H4 extensions, H1 extensions, instead of going and stamping in the consulate, they're going to get the stamping in the State Department, like the way it used to be before, where we used to pay $100 mailing to Washington DC office. You're going to bring a lot of jobs back to India, back to USA from other countries. The consulate's burden will reduce by about 30-40%. Okay.
I would get rid of these stupid biometrics.
Biometrics, okay.
At least for the H4s and the F1. They're only suspended for H4s. Okay. They didn't get rid of it. It's coming back in September.
Yes. For B2s and, okay.
So that's the first thing I can think of.
What I would do is, Emily, what I would do is that I would put a quota for each employee that who is adjudicating the 485 applications, or any application actually, that if they don't complete that quota though, whether they are a sick leave, they want to do anything, they'll be put on suspension. And for the people who are adjudicating more cases though, I will give them the reward monetary wise. Interview, definitely I will avoid those things. What else?
Fire all the service center directors.
Fire all the service center directors, but I will not fire them immediately though. I will fire them like the way Bush did it. They will be fired in 6 months if they don't bring the processing times of the 485s to 6 months, EAD and advanced paroles to 3 months, I-539s to 3 months, I-129s to 3 months. I will fire them. You are fired 6 months from now if you don't bring them. Good question, but let's see, our USCIS director does all these things though. Question come from R&R. My private date is January 2006, currently in EB3. Is it good idea to move EB2 or stay in EB3? It's a very good idea to move to EB2. Now, it's not like you're moving though. You have 2 options available. If your employer files the EB2 I-140, you have EB2 and EB3. You can go whichever thing you want to. So definitely R&R, I would make all my efforts to get my I-140 approved in EB2.
Siva Koti says he's written the letter to his congresswoman and is planning to travel to India in July to August. For H1 and H4, there are no drop box appointments available. He's expecting the PERM labor to be approved this week and wants to know what are the chances that I could get an advanced parole if we filed I-140 and 485 together right now. To get that by July, I would say 0.00001% or maybe a negative percent. They're just not doing it. The only way you can do that is after you file it, request an expedite and actually have the expedite work. But the way the expedite works, you call customer service, you go through all this rigmarole to talk to a live person. I did it first thing this morning and it was the most frustrating thing I've done in a very long time, trying to get to a live person. Then I tried the live chat with Emma, couldn't get anybody there. But assuming you can get one of these people and tell them you need to expedite, then you give them their information and they say, we'll email you the decision in about 24 hours. And 24 hours, if they actually say, yes, we're going to expedite it, then it's probably going to take another 2 months for them to actually give you the expedited service. So even with all of that, very unlikely to get it in time, unfortunately.
I'm going to combine 2 questions into one. Manu is asking the question, when a lot of people have filed from EB3 to EB2, why isn't EB3 dates moving? Then comes the question from Marsh. He wrote the letter to the congressman. Sorry, it's not from Marsh, it's not from another gentleman where he did interfile the application. This is from Vikram. He did interfile the application in January 31st. No receipt notice yet. What to do? Should I refile the application? I combine both the things here because one, Vikram, it's up to you if you want to refile the application. Anyway, you're just sending the copy to. There are some cases that we are not receiving a receipt notice of the interfiling at all. And at this time though, the interfiling adjudication is at a slow pace. They would, when they introduced the interfiling with a particular address, I think so they did not have a clue of how many people will file an interfiling application. They definitely received a truckload of the interfile applications in the first 3 weeks, and they're still sorting them down from the January to all the way to February ending. They haven't sorted them, all of those things out. That answers your question, Manu. Why when these people are filing EB2, the dates are not moving for EB3, because they are not approving the cases even though we file them in interfile them in EB2. So the whole thing is backlogged there, where there is they are not adjudicating the application. To answer the question for the other gentleman who asked that, what would you do? This is another thing. I don't require interfile to approve a case in EB2. If I have the EB2 approval in my file, if I have the EB3 approval in my file, what is preventing me to approve this case though? That's a change that USCIS director should bring in. Instead of giving an address in California, we changed our adjudication process. Now, if we have a file of EB2 under approved, we will adjudicate your case unless you have a problem. I don't think so any of our clients will have a problem. So definitely that could be done unless there is cases which involves the age out kids. Other than that, they should just adjudicate the applications. And instead of adjudicating the applications, they're telling where is the nose. They're telling the nose is all the way. You go all the way to California, and then you come back here, and then you go back here, and then you come back here. That's when we're going to adjudicate the 485 under EB2. Why couldn't they do it? They have it here. EB2 is here. EB3 is here. This is a nose. Done. They should have done that. They have an authority to do it. There's nobody who's preventing it. These are the bureaucratic things the USCIS need to change, and we want you to point out by writing the letters that we are drafting and giving it to you. Keep writing those letters.
Chan says in the EAD approval notice, it says, quote, if you have a pending or approved I-140 and a pending I-485 for more than 180 days, you may request to change the employer. Does this mean we can port the AOS even if the I-140 is pending? Technically, yes, you can. AC-21 just requires that the 485 be pending for 180 days. It technically does not require the I-140 to be approved at that point. However, there is risk involved in that. When you port based on a pending I-140, you may be later asked to prove that that old company's I-140 was approvable when it was filed. You may not have access to that employer or any of the documents needed to answer that question. So that's why we generally would say it's best to wait till the I-140 is approved, plus the 485 being pending for 180 days before porting.
Srini has this question, wrote the letter to the congressman, thank you, filed 485 without birth certificate, non-availability certificate, but submitted two affidavits. That's good. My birth certificate is different than on my certificates. Can I, if your birth certificate is different, birth date is different though, Srini, I want you to contact an immigration lawyer. I may be a better lawyer, I think so, because one of the reasons is that I'm a lawyer in India. I'm also a lawyer in the United States, in both the countries. I may be a better person, or contact any lawyer who has more connections to India and maybe even licensed in India too. That may resolve it much better, rather than don't send that birth certificate to USCIS. They'll get confused. One date says July 3rd, 1984. One says that February 6th, 1986. I mean, that's going to confuse them. Please speak with a lawyer before you do anything on that one.
Prasad says the USCIS website now states 22 months from the receipt date to file an inquiry for the 485.
Wait. The processing times of USCIS have been changed right now. Can you explain what's going on that?
I don't think I can. It's so
What do you mean?
confusing.
You are an immigration lawyer. You've been working for so long.
So up until last week, they gave us a range of processing times where the low end of the range was how long it took about 50% of the cases to be approved. And the high end of the range was how long it took 96% of the cases to be approved. So if you're close to that high end of the range, you have a pretty good likelihood that you should be getting something soon, because 96% of the cases are taken care of within that time frame. Only 4% are left out, a very small number. Now, we're going to look back at all the cases we've approved in the last 6 months and tell you how long it took us to approve 80% of those. Now that leaves out 20% that could have been pending for who knows how long. And we're just looking at the last 6 months. What about 10 months ago when everything was...
Well, I'm getting confused, Emily. Previously, you said 96%. So if the processing time is anywhere between 10 months to 22 months, so that means that by 22 months, 96% of the cases that were being filed got adjudicated.
Yes.
Then it's 10 months is a lower end, means more than 50% of the cases got adjudicated. So between 50 and 96 were in this range from lower to end. Now what is the range now you said?
There is no range, it's just 80%.
Only one date.
One date.
And that is 80% of the cases are approved.
Within the last 6 months. So they're only looking at how they did in the last 6 months.
Okay, wait. If it's the last 6 months, if my case, they put a date there, let's say it is 18 months. If my case has been filed 19 months ago, can I not raise a service request?
We're not sure because now you plug in your case receipt date and it will spit out a date that says when you can put in a service
That is
request.
in the service request column, not
it's
in
within the processing time.
No,
still.
so if I put in the receipt notice, it won't tell me that.
No.
You have to go to the service request.
Now you go to the processing times page, put
Okay.
in your case type, your form type, then what type of case it is. They have a much bigger list. And then the service center. And then it tells you the 80% number. And then you scroll down even further and it puts a little thing and says, put in your received date, and hit enter, and it spits out the date that you can put in a service request. So for everybody who filed in October 2020, it's saying you have to wait until August 2022 before you can do a service request if your case is still pending.
So if my case has been filed in October of 2020, when can I raise a service?
August 2022, but I guarantee you when you get to August, that date's going to change.
So please keep writing the letters, guys. And from now onwards, we'll try to promote the people who have written letters that we are going to answer those questions more. Pooja Jain has this question. I-485J got approved. I-485 status is pending. What can be expected next? Assuming that you do have your priority date, final action date is current though, any time it is expected. Now that's the time, now we can't tell what that any time is. But what in general, Pooja, that I can tell you is that if the I-485J is been approved though, you have a greater chance of getting the approval of green card much faster.
Paul says, can we continue working with the current employer on H1 in order to maintain the non-immigrant status and take up a part-time job on the EAD? No, once you use that EAD, you're no longer in H1 status. Now, can you keep working for that employer and take on the part-time job? Absolutely, no problem, but you're no longer in H1B status the minute you use that EAD.
Shilpi has this question. We got both Dropbox interview appointment and different dates. I mean, there must be a couple. Is this common? What can you do for this? Well, just take it. I mean, it's normal. Sometimes people get separated when you try to book an appointment. I don't see any problem in it that both of you guys are going separately.
Manu has a good question. Why are the EB3 dates not moving forward when all of these people are
I
interfying back to
answer the
EB2?
question. Mohit has this question. Can we interfile to EB2 when pending EB3 I-140, both with the same employer? Mohit, you can do it, but I recommend you do premium processing of the I-140 and do the interfiling of the EB2 though. That would be more ideal for me because you don't want to, once your file hits the officer desk though, you don't want him to give any chance to delay it, because what he will do is that he looks into the file, everything looks good, I'm going to approve this. If he thinks so that there is something that, okay, I'm going to put on this desk, and he forgets it, and that happens. And these are bureaucrat people. I mean, you know how the government employees work. Same thing back in India and here, it's all the same people they work. The only thing here we don't have is definitely, they don't have bribes here. But they're the same guys. They just put your desk. So that's the reason I don't want to give any excuse for the officer. You give everything to the officer, there is a good chance that they will approve it. You don't give a particular thing, they don't. So that's the reason I want the EB3 I-140 to be approved though, before you file interfiling. Is it illegal to interfile when the EB3 I-140 is pending? No, it is not. It is not. You can still file it. The other good news, Mohit, is that the premium processing is accepted right now. They're accepting the premium processing. Go ahead, I'm sorry.
Sure. Rajesh has written a letter, and he says he filed the new EB2 I-140 after the old EB3 was done as an amendment. However, the new EB2 I-140 receipt notice says April 2022 is the priority date instead of the old priority date of January 2013. Is this okay? Yes, this is totally normal. I had a client, my own client, email me the exact same issue this morning, all worried because his receipt notice came without porting the original priority date. The receipt notices always come that way. They don't actually port the date until the case is adjudicated, because at the time they're issuing the receipt, they haven't looked at anything yet. They're just putting, this is the date we received this file, because there's no because the labor certification has that new date on it, because you're filing it now. But yes, this is totally fine. Don't worry about it. As long as it was requested and the documentation was submitted in there, your I-140 approval notice should come with the old priority date.
Questions, very interesting question from Sachin Kumar. Would a change of residential address necessarily result in the change of service center and hence chances of faster adjudication? Unfortunately, no. Unfortunately, no.
You just go to the other black hole. It only goes from Texas and Nebraska, so they're both black holes.
But yeah, they won't even, it's not, you won't do anything good by changing the address. Believe me, if that's a question, a lot of our clients will be changing the address.
Vineet says he downgraded to EB3 in October 2020. It's at the Nebraska Service Center. His priority date is April 2014. Do we see any risk in doing a refile, or do we recommend sticking to the interfile? Asking because the attorney says he's not confident. So I guess the question is he not confident that one is going to be faster than the other, or is he just not confident that you can refile? Because we've made so many videos on this, because there's so many people saying you can't file a second 485. That's illegal.
They change their dialogue right now. When people,
now they all agree that it
now
can be done.
Since people got getting approval, then they changed it. Didn't they said that you can't even downgrade the application?
Right.
Did you said that you can never file premium processing if the I-140 is a downgrade application?
Yeah, so as long as you have maintained your non-immigrant status, you have the choice of refiling or interfiling. We just don't know which one will be faster, but there's no problem legally with refiling.
Very good question. Question of the day today. Jai Shankar from Facebook has this question though. Should I update my I-9 because my current employer right after using the advanced parole? If you are on H1B and or H4 EAD, and if you have used the advanced parole, you come in though. The USCIS is telling right now that they are extending the H1Bs. That means that they are telling the H1Bs are valid. If that is the case, there is absolutely no, and that is the case actually, that your H1B is still valid and your or H4 EAD is still valid. You are under absolutely no requirement to update the I-9 with your EAD. You're perfectly fine.
Sachin wants to know, what's the trend on 221Gs? Have we seen a dip in this, or is it still the same as the Trump administration? I would argue it's more than the Trump administration, because remember, during the Trump administration, no one could go for stamping because we had the COVID bans and the India ban and the H and the L ban and all of those things. So there weren't any 221Gs during that time frame, but now I'm seeing quite a few of them. Even for household name companies sometimes. It's very odd. But yes, I'm seeing more than what I was seeing before during the Trump administration.
Standalone fresh H4 EAD has been pending for over 210 days. I'm looking for losing a lot of job opportunities. What are my options? Oh, you can only request congressmen, ombudsman. Those are the things that you can look into. If the person isn't going to work in healthcare industry, that's definitely a good chance that for them to get the expedited approval. But other than that, I don't have any methods to expedite that. And please don't pay us consultation fees to expedite the EAD. We cannot help. We actually cancel our appointments and then say, hey, we can't do this. It's a waste of time, guys. We can't help you out in expediting the EAD, please. We can't.
Benu says, one of the employers I worked for is not giving the experience letter. What are my alternative options for the I-140? So number one, I would make sure that you actually need to get one from this employer, because you don't have to provide experience letters from every employer. It's only enough to show that you qualify for the requirements of the job. So if the job requires 5 years of experience and you have 10 years of experience with different companies, you could potentially leave out one company and use the other companies to meet that 5 years. But assuming you do actually need it, I actually have a blog post on immigrationgirl.com. It's kind of an old one, but it's still valid. Exactly answering this question about how you can potentially get affidavits from former coworkers, along with secondary evidence such as W-2s and pay stubs to meet that requirement. So if you go to immigrationgirl.com and look up experience letter or no experience letter I-140, there's a little search function there. You should find that article with instructions.
This 2552 wrote letters to the congressman. That's good. EB3 downgraded and pending since 2020. April refiled EB2. Can I change my job? Per EB3, I meet AC21, but per EB2, I have to wait for 108 days. You're right. You can change the job under EB3, but EB2 might be at risk, though. At risk. Very significant risk. But EB3, I don't see any risk whatsoever at all for EB3 if you got a job opportunity to move into. Question that comes from Prashanta from YouTube. Can I port my priority date when I move from employer A to employer B? There is a job description change in the same engineering. He's a mechanical engineering. For porting the job from porting the priority date from company A to company B, though, you don't have to have the same job at all. You can move from company A as a software engineer, company B as an as a lawyer, because they don't match. I mean, we are not computer programmers for sure. So porting the date from company A to company B, it doesn't have to match. When does the job description have to be similar? Not matching, but similar, is when you file a 485 application, though. You're moving from company A to company B. The company B job description has to be similar. Now, a lot of people are paranoid about this one. They always ask me the question that my job description is not exactly the same as it is. Well, let me ask you one question though. Are you a robot? Like every day you come to an office, tack, tack, tack. You go left, you go right, you drink coffee, you press the buttons, and then you come back. No, every day your job is different. It's not the same coding that you do every day. Every analysis is different though. It must be in a similar occupation. For example, if you're a mechanical engineering and you moved into software though, that may not be considered. But within mechanical engineering, there may be different aspects though. So you're fine, that would still be considered. What if you are from SAP and now you moved into .NET? For us, they're all the softwares. For you guys, they may look different, but for us, they're a software. We don't see that as a problem at all.
Abhijit has written a letter to his congressman and says, now that we have the extra 540 days for the GC EAD, is there any hope of actually getting the EAD within this additional time frame, or is it just USCIS kicking the can down the road? I'm going to go out on a limb and say they are kicking the can down the road. I have zero hope that they actually intend to process these within that time frame. I think their hope is maybe if we hurry up and can approve their green cards, we don't need to worry about this, which that would be great. But I have a feeling they're going to mess up and not get everybody's green cards approved, and now they've put these on the back burner for a year, and then we're going to be scrambling again.
Emily, a question for you, if you would, is that if people are filing the labor certifications and it's taking 7, 10, whatever years for them to get the green card, and if there is a small promotion in the job though, do they need to file a labor certification again though?
Yeah, there's definitely two schools of thought on this, but I think the majority school of thought is that look at it, is this a typical career progression? When this process is taking a decade to go through, at some point we would expect that you're going to get a raise. At some point we would expect that your job is going to become more complex, or you might start supervising people. Typically how I handle that situation when it's time to file the 485 and I now have to submit that supplement J, I explained that the job is basically the same, but due to the passage of time, the duties may have expanded. I've not had any pushback on that except in one case that was eventually approved. So
did you had any of the 485 denied? Because let's say, for example, I'm not supervising anybody right now, but then I'm supervising 2 or 3 employees as time progress 7, 8 years afterwards. So.
No denials on that. And I think that makes sense. It would be ridiculous that every time you get a raise and every time your job becomes more complex because of the passage of time, you're going to have to get a new perm. No one's going to go through that process 3, 4, 5 times over a 10-year period before they get the 485.
And for the software people, these softwares completely changed.
Yeah, what you put on the perm 6 months ago, you probably don't even do that anymore.
Most of the companies, like FANG companies, what you guys call it, is technology companies, they are of the same opinion like ours. Their lawyers are also of the same opinion. But there are some immigration law firms that just want to, their purpose is to just benefit themselves. They keep on telling, $5,000 salary increase, let's refile the entire PERM, let's file the, but we don't think so that's a good practice. And most of the lawyers they don't think so that's a good practice, and we have never seen anything else.
I saw a couple questions about traveling with the H4 and EAD extension pending. We've talked many times about using the automatic revalidation as a way for the H4 spouse to get that 540-day automatic extension. You're eligible for that too, but you have to get the extended I-94, and you do that by traveling. So the general rule is that if an extension is filed, you can travel while an extension is pending, and you don't abandon the extension request. You have to be in the U.S. at the time of filing, and then once it's approved, you either can come back into the U.S. at that point, or if you come back into the U.S. while it's pending, you may have a mismatch in I-94 numbers, but that's not the end of the world. It should not cause your extensions to be denied in any way, because it does not abandon an extension request. Travel during a change of status request does abandon the change of status. So I think that's where people get confused on that. But I've not had any issues with people traveling while their H4 and EAD are pending, going and get the visa stamp when they could and coming back, or those that use automatic revalidation by traveling before the current one expires, after their H-1B spouse gets their approval, use automatic revalidation to get the extended I-94, and once you have that, because your EAD was filed before it expired, you get the 540-day auto extension.
Question from Border from YouTube. Does EB1A preference in processing of the I-485? If yes, what kind? There is no official policy that the EB1A should get any preference. Having said that though, but in general, we do notice that the officers do approve the 485 much faster, only if you have had the EB1A approved before you file the 485. That means that you get the EB1A approved and then you file the 485. We notice that those 485s that get approved in EB1 normally move much faster than EB2 and EB3. But there is no official policy on that. Anything else?
I think we are out of time for today. Thanks so much for joining us. Please remember, you can always subscribe to our newsletter to get all of the latest articles that we publish almost daily at rnlawgroup.com, and you can get up-to-date information at immigrationgirl.com by subscribing there as well.
And don't forget that we do have a daily conference call that we do answer for a half an hour every day free. You can come and join, and you can go to RN Law Group and you can get a link there, and you can make an appointment with me, Emily, or any of our colleagues at any point of time at RN Law Group. Our schedule is there. You can book based on what schedule is available, what schedule you are free.
Thanks for joining.